Welcome back to Mortgagenomics Canada. I'm Marko, Gelo, a duly licensed mortgage broker in British Columbia and Alberta. If you're in either province and need mortgage advice or service, reach out. One application, one credit check, and access to Canada's top lenders. Today, I want to talk about land titles and the various applications of adding or removing someone or ownership, and the implications that may arise as a result. Some of them totally negligible, not a big deal, and some extremely serious and potentially very costly. Changing who appears on your property title is one of the most significant legal and financial decisions a homeowner can make. Whether you're adding a spouse, removing an ex-partner, or planning your estate, understanding when and why to modify property ownership can have major implications. In this video, I've narrowed it down to about 5 most common applications that British Columbia and Alberta homeowners do when making changes to their property land title. And I am only speaking to Alberta and British Columbia because I am licensed in those 2 provinces. So if you're listening from other provinces, you're going to have to dig deeper or contact a lawyer in your respective region and verify further. So let's start with the first application: adding a partner to your land title as a result of a marriage or new relationship. Marriage or a long-term partnership often prompts homeowners to consider adding their partner or a significant other to the title, but it must be approached with a complete understanding of the consequences. Let's start with the benefits of adding a spouse. Adding your spouse as a co-owner creates what's referred to as a joint ownership, which gives way to what's known as the right of survivorship. In both British Columbia and Alberta, property held as joint tenants automatically transfers to the surviving spouse upon death, thereby avoiding any probate delays. Next up, on the flip side of adding a spouse, another very common application: removing your ex from title as a result of divorce or separation. Separation or divorce is one of the most common reasons homeowners remove a name from title. You can't unilaterally remove someone from title without their consent or a court order. The change must be supported by a written separation agreement or divorce judgment. Typically, one spouse buys out the other, arranges new financing through a mortgage if needed, and the transfer is registered through a lawyer or notary. BC allows for notaries or lawyers, whereas Alberta requires only lawyers. In British Columbia, transfers between spouses or former spouses made under a separation agreement or a court order are exempt from the property transfer tax. In Alberta, it's not applicable because there is no property provincial land transfer tax. They only have these minor registration fees that apply, nothing like the property transfer tax in BC. If refinancing is involved, you may need consent from the existing lender, a new mortgage registration, and you might also incur penalties, break penalties or legal fees because you are making material changes to the land title. And this essentially triggers a discharge of the original mortgage, thereby resulting in mortgage break penalties, if applicable. On to application number 3, estate planning, adding children or family members. Another very popular one. Many parents in British Columbia and Alberta consider adding young children to title as part of estate planning, usually to avoid probate or simply inheritance. But be very careful here, as there are definitely some hidden dangers. This could seemingly come across as simple and logical, but it can result in serious risks. Number 1, exposure to the adult child's creditors. If your adult child faces debt, divorce, or legal issues, your home will become vulnerable. It'll be a part of their problem because they are on title. Number 2, potentially immediate, this is the big one, capital gains. Adding a child creates a disposition which can trigger capital gains tax on that portion, even if no money changes hands. And finally, the loss of control. This one's massive as well. Once your child is on title, you can't sell or refinance without their consent. Okay. In both British Columbia and Alberta, most estate lawyers will discourage adding children to title. Instead, they might recommend naming them as beneficiaries through the will, using a trust to hold property, or adding what's known as a registered life estate, which honestly I don't have a big idea of what that really is, but I've read that this preserves control while designating future ownership. So check that out. But the bottom line with this one, adding children or family members, be very cautious. It could be costly and very problematic if it's not done for very specific reasons. So yeah, once again, I need to remind you, do not act exclusively on anything you are hearing in this episode. Be sure to seek professional estate planning advice before proceeding. This information is simply meant to make you aware that there are serious consequences to making any changes to your land title. If you are contemplating anything that I have discussed so far, take further action and consult with your accountant, your lawyer, or your estate planning professional for further advice and direction. Okay, we're not done yet. 2 more points to discuss here. Let's talk about business and creditor protection, also known as strategic structuring. Business owners and professionals in both British Columbia and Alberta often review title structure for asset protection. If you face business liability, professional claims, or debt judgments, creditors can register liens against property you own. Title structuring may offer protection, but timing is everything. Transfers made after you become aware of risk can be overturned as fraudulent conveyances. Strategic structuring should always be done proactively and with guidance from a lawyer familiar with BC's Land Title Act or Alberta's Land Titles Act. And lastly, let's talk about financing and mortgage considerations. Sometimes title changes happen not for personal or estate reasons, but rather to optimize mortgage qualification. Adding a co-signer or owner, for instance, like a spouse, parent, or business partner, with strong income or credit can help you qualify for a mortgage that you otherwise wouldn't. Lenders look at combined income and credit scores when assessing risk, so a strong co-signer might be the X factor that gets you past the finish line for a mortgage approval. And also conversely, removing someone may improve your qualification if the co-mortgage or the co-applicant has poor credit, or you may want your spouse to qualify as a first-time home buyer for another purchase, thereby wanting to remove them from this particular purchase that you're looking at. And finally, like at the end of the day, you need to ask yourself the following before you consider making any changes to your title. What are you trying to achieve? What are the tax implications? And are there any better tax efficient or safer alternatives? How will this affect your estate or your mortgage? Is everyone protected if circumstances change? Changing title is a serious and complicated legal act. Once registered, reversing it requires cooperation from all parties and can often be unreversible. So seek professional guidance from a real estate lawyer and tax advisor to ensure every step is done correctly. That's it for today. If you're in British Columbia or Alberta, reach out anytime, 604-800-9593, or visit homefinancingsolutions.ca. You'll find past podcast episodes, market blogs, and even my mortgage app, which includes calculators, rate trackers, and a quick pre-qualification feature for you to explore. Thanks for tuning into Mortgagenomics Canada. Stay well and talk again soon.